So 59% of you expected me to be found guilty for the Section 5 public order offence I was charged with for saying no shit to a police officer. Can't say I blame you. I expect to be found guilty myself. It is, after all, Magistrates Court where everyone, including criminal defence solicitors, are doing their utmost to ensure guilt is found. Many people offered to help pay my legal fees, but I declined because I didn't want to waste their money. Most solicitors are incompetent, and finding a decent one is the proverbial needle in a haystack. Furthermore, I intended to make a human rights claim, as I am entitled to under Section 7 of the Human Rights Act. But the judge at my pre-trial hearing refused to allow me to speak, even though the Magistrates Code make it clear you can bring up a human rights claim at pre-trial. That in itself was grounds for appeal, so I figured the Magistrates Court trial was just a pointless formality. If this was how I was going to be treated, there was no chance of a fair hearing, so I'd refuse to participate, let them find me guilty, and then get a retrial at Crown Court. When I got to court, however, there were 3 magistrates instead of a bastard district judge. A totally unexpected advantage, especially as I didn't have a solicitor to fuck it all up for me. Defence solicitors are totally oversold in my opinion. All they're really good for is shepherding clients through the mystifying court process. They never formulate a suitable defence, and the best they offer is to mitigate the sentence when they get the inevitable guilty plea they're expecting. And do they honestly think those sob stories actually work? The same stock excuses they use for every single client without a hint of sincerity. The magistrate's eyes just glaze over at that bit, and the client, never having been in court before, thinks the solicitor's sticking their neck out for them. They're not. A solicitor will never do or say anything that might reflect badly on them. They have to appear in that same court day in, day out. You're only likely to be there once. They're not going to say anything that might upset the bench or have them remembered for their next trial. Some people suggested hiring a barrister, which is a very different animal, but I felt like that would be using a sledgehammer to crack a nut. Because one thing I know about magistrates is they don't like banging up their own kind. Present yourself as well-dressed, well-spoken and respectful, and you'll get a very different response than those that obtain their court attire from JJB Sports. The only fly in my ointment was that I had a court-appointed solicitor to do my cross-examining for me, because I'd been prevented from doing so by a malicious Section 36 order slapped onto me by the pre-trial judge. The solicitor listened intently to all the important questions I wanted asking the cop. Needless to say, as soon as the solicitor got into the courtroom, he disregarded everything I'd requested and asked exactly what he wanted to ask, which was as good as nothing at all. He didn't even bother to ask the cop why he'd waited a month to prosecute me, nor did he ask him if he knew that courts don't in general accept that police officers are victims under Section 5 when they hear swear words in public. Compare this to the prosecution, who grilled me like it was going out of fashion. Again, defence solicitors are so terrified of offending the witnesses, they daren't adopt anything other than mild questioning, unlike the prosecutor, who couldn't give a toss. And up came poor PC Snowflake to tell his story. The video link wasn't working that day, so he had to turn up in court, bless him. He slithered into the witness box, with his voice breaking like a 13-year-old boy whose balls have just dropped. Needless to say, being a police officer, he lied at every opportunity. When asked if anyone other than himself had complained about my behaviour that day, he suggested that yes, others had indeed complained, but strangely it was unsubmitted evidence. In other words, it didn't exist, no one had complained, and what he just said was inadmissible. But he said it anyway, in the desperate hope he could get me convicted. Then it was my turn to give evidence, and this is where self-representation paid off. I could hardly cross-examine myself, and nor would they allow you to read out a statement, unless it's something you wrote down at the very moment it all happened. Instead, the clerk assumes the role of the cross-examiner, and they are trained barristers, so she did a thorough and excellent job of it, far better than a solicitor would have done. She teased out every important issue, even some I wouldn't have thought to mention. Even the magistrates were asking intelligent questions, which had the prosecutor fuming. To give you an idea of just how useless defence solicitors are compared to even the clerk of the court, take this situation that occurred partway through the trial. Because I'd refused to go with the cop for a voluntary interview, the prosecutor insisted that an adverse inference be drawn from my silence. In other words, the defence I was now given in court was clearly rehearsed and possibly fictional because the police had never been given the opportunity to test it. Now, I know that no adverse inference will be drawn from a refusal to attend voluntary interviews, which is why I advise everyone to decline them. I've written about it extensively on my website and in my books. Of course, defence solicitors have a superficial understanding of the law at best. They have no grasp of such technicalities, and if I'd employed one, in all likelihood they'd have made no objection. But before I could get a word in, the clerk stood up for me and told the prosecutor he was talking rubbish. Adverse inference only applied to questions asked. As I'd never given the police the opportunity to ask those questions, then there was nothing they could do about it. The prosecutor, knowing he was outmatched, slunk back into his seat and shut his stupid mouth. It was fairly obvious to me from that point the court was on my side, and after a recess for lunch, I came back in to hear the verdict. Not guilty. The magistrates accepted that no one had been offended by my behaviour and no one had complained, and given the circumstances, everything I'd said had been totally reasonable. They stopped short of saying what a lying bastard Officer Snowflake was, or rather 14690 Matthew Ward, as his actual name is, because now the case is over and he's had his day in court trying to take his spite out on me. Now it's my turn. And unlike him, I won't foul. I'm going to sue Derbyshire Police for malicious prosecution and breaching Article 5 of the Human Rights Act with what was nothing more than an affront to this officer's fragile ego. As for the obnoxious judge who ridiculed me pre-trial, I reported him to the Judicial Conduct Investigations Office. The icing on the cake is that PC Ward and the circus of clownery that is Derbyshire Police have had over 1 million views exposing their failed attempt at malicious prosecution. And what greater justice is there than public humiliation via YouTube? Thank you, YouTube, and to everyone who watched. If you wish to support this channel, then please consider purchasing one of the e-products I sell from my website, or maybe making a donation.